Hi there, my name is Megan Freed, and I am joined by two of my favorite lawyers in Connecticut, Claudia and Kathleen from Disability Planning Partners. Can you introduce yourselves and tell us a little about you before we dive into our main topic of today, which is the two main things that you can do to prepare in case you get sick? We are so glad to have you here. Kathleen, you are up.
Oh, why, thank you. We're so happy to be here. Claudia and I are the co-founding members of Disability Planning Partners. We are in Hartford, and our practice focuses on estate planning as the foundational piece of everything that we do, and working with clients, whether they have disabilities or not, to plan for the future.
Thank you. Claudia.
Yes. Thanks for having us.
Thank you for being here.
Thanks so much for having us. We love collaborating in our partnership with you. So thanks for having us. I ditto what Kathleen said. We're just here to try to get some messages out to our community in this unprecedented time and make sure that anyone who's watching or listening can share some of the information we're going to talk about today, and should feel free to call us with any questions at all. We really want to be able to support our communities.
Thank you both. So the first thing I want to talk about, because it's something that we hear so much, even in the context of Freed Marcroft's divorce and family law practice. So as you two know well, we work together a lot with Claudia and Kathleen because where we leave off, the estate planning picks up, and then there's a period of overlap there. So we work together closely. And one of the things I know that people wonder is really relevant for today, because this word estate planning implies that someone has died, right? We don't have an estate feels like something that happens after death. But some of our focus today is going to be on documents that help you prepare in case you're ill, right? Very much alive, but unable to make decisions for yourself. So I just like to start with the definition of estate planning so that everyone knows that this isn't a discussion about only what happens if the worst case scenario happens. It's also to prepare for an illness.
Exactly, Megan. Thank you. So one of the two biggest documents that can save anyone during life are a power of attorney and an advance directive. And the overriding premise of both documents is that a trusted individual is named to act on your behalf with respect to financial decisions, if it's a power of attorney, and medical decisions, if it's an advanced directive. So when we talk about these documents, I like to use an analogy akin to the 5 W's.
Right.
So the first question that we tackle is, who needs this? Really, everyone needs this. Everyone needs these two documents because
whether there's COVID or not.
Whether there's COVID or not. And the reason that it's so relevant right now is because I'm gonna go on a limb and say most of us were not expecting this, right? So the catastrophic effects that this virus has had in our private and personal lives and our business lives may come across a very unexpected injury or event. And these documents protect you in your lifetime by appointing an agent to act for you. So as an example, right now we have college kids that are home. Mm-hmm. Anyone over 18 years old should appoint an agent, usually a mom or a dad, but it's a really good time for that demographic of kids that are home to look at this type of planning. It's also really important for business owners to have someone that could transact business, carry on business in the event of illness. So Kathleen and I are partners. We have documents for each other related to our business so that either one of us would be able to act for the other one if one of us became ill.
Right.
So right now, the when is my favorite part, the when and the where, because we can do it right now and we can do it remotely. So our firm moved to a remote platform pretty early on. And because of the clients that we see most often have some vulnerabilities, and we wanted to be overly protective.
Mm-hmm.
But I'm working out of my home office, as is Kathleen. So schedule a time to talk to us at 7 a.m. over that coffee cup. We have far more flexibility because we are remote. So let me tell you a little bit about each document in a little bit more detail. A power of attorney appoints an agent, typically a spouse, a best friend, a sibling, someone who knows you very well, knows what decisions you might make, and that you trust. Once you appoint this person in a power of attorney document, that person could do any financial transactions that you would have done yourself. They have to ensure that it's your interest that is being protected, but they can do anything that you would do, which would include creating trust or maybe adding beneficiaries to accounts. A lot of things can happen in life that prepare you for passing property or simply managing day-to-day business. So that's really important. The other document, it has a lot of different names, either an advanced directive or a healthcare agent appointment. But the things that become important there are making sure that also an agent is appointed to make medical decisions for you. Here's the catch. The agent has to know what your wishes would be under different circumstances.
For the healthcare one.
You know, there's very limited situations in Connecticut where a do-not-resuscitate or a do-not-intubate order would be done. And fitting into those two segments is really if you have no brain function or you have been diagnosed with a terminal disease. So what happens with everything in between? It's hard to have the conversations, but you have to. We encourage everybody to have these conversations. Once that agent is appointed, you don't need to worry whether something's going to happen to me and no one's going to know what I want,
Right.
Because you would have already planned. The piece that goes hand in hand with that is authorizing someone to receive your protected medical information. So most of us know this is a HIPAA release.
Yeah.
What's important is that when we go to our doctors, at least mine, I sign the little form, who can receive information on my behalf about my medical conditions. But if you're sick or ill suddenly and you were traveling or you're in a different medical system than maybe your primary provider, those physicians are going to need a separate document that they can refer to be able to disclose information about your health. So this is a blanket document that would apply anywhere. Right.
Just because of Fried Markroff's divorce and family law practice, let's talk a little bit about when we're talking about naming the right power of attorney or the right healthcare agent. We talked about the business context and in that case, partners like the two of you would name each other. I think something that's confusing for people is whether or not a spouse can automatically make these decisions for them. And so following along with that discussion, what you can do if you are realizing that you might have some of these documents in place, but they might not fit for you anymore if you're in the middle of a divorce. So I think, could you talk to us a little bit more about what the default is if you don't make have these two documents in place?
Kathleen, you want to address some of those issues?
Sure. So the default is often undesirable, and that's because you're not in control. So part of what Claudia's been talking about is when you're of sound mind, when you have the ability to sit down and plan, you're actually putting pen to paper and putting your wishes in writing and having conversations about what's important to you.
Mm-hmm.
If somebody hasn't planned, a spouse does not have the automatic right to start making decisions on behalf of another spouse. So for example, if you have a married couple.
That's very confusing for people. I think that we can't emphasize this point strongly enough, that that taking action to do these documents is really critical.
Yes, it's an absolute necessity, and it can really wreak havoc on your life if you haven't done it. So for example, if you have a married couple and they don't have joint accounts, and one of the individuals is in an accident, let's say, and maybe they're the primary holder of all of their accounts, the spouse, if they're not a joint owner on the account, is not going to have the automatic right. They're going to go to the bank, and the bank is going to say, well, show me your authority, show me the power of attorney. And the authority is not your marriage license. It has to be a power of attorney document. So if somebody doesn't have that in place, what happens is you actually have to go to the probate court in the town where the individual who now has lost capacity resides, and the court has to appoint somebody to act on that individual's behalf. And that might not be the person that you would have chosen to act on your behalf. It could be a family member that doesn't have your best interests at heart, or maybe doesn't understand what your interests or wishes would be. If there's nobody to act, it could be a court-appointed attorney who never met you when you had capacity. And even if it's your spouse, even if it's that person that you trusted and would have named, the probate court is now involved. Once the probate court is involved, for example, in finances, they're always involved. And so what that looks like is sometimes getting approval from the court to do certain things with your own marital assets. It involves reporting to the court on an every year, every 3-year basis as to how your finances are used. And that's very invasive. When the alternative is very simple, and as Claudia said, you can do it now, you can act very quickly, make sure not only that your wishes are taken care of, but that you maintain the integrity and the privacy of your financial and health life, as I think we all would choose.
I think that you made 2 really great points, Kathleen. One is that like this is urgent. It's actually been urgent for years, right? It's not just urgent because of the COVID pandemic. It's urgent because we should always have these in place. And I think that one bright side of this might be that people are becoming more aware of what the absence of having these documents
exactly
the problems that can create. The other piece of good news is that they aren't hard to do, right? You and I'll just, Kathleen and Claudia have a very sophisticated disability and estate planning practice. This is not the most complex piece of what they do, but it is the very basics and the most critical basics that need to be done, and they need to be done early, and they need to be done correctly. And this foundation sets you up. And just quickly with the point, if any of our clients are listening and they're in the divorce process and perhaps their spouse might not be the power of attorney that they would currently appoint, might not be the healthcare agent that they would currently appoint, talk with your Fried-Markgraf legal team. There are certain things that we can change during a divorce. Those are among the things that we can change. And there are certain things that we can't change during a divorce. For example, the beneficiaries of a will, right? We can change who makes decisions. We can't change who inherits unless there's an agreement or a court order. But your legal team can guide you through it. So for our divorce and family law folks, I just want to make sure that you know that these are things that we can coordinate with Claudia and Kathleen and get you taken care of, so that the person that you want to make decisions is the person making decisions for you. Great. So I sort of deviated from our plan there because I thought of that. So to just bring us back, Claudia, you were telling us more about the power of attorney and the healthcare directive, and you made the distinction between, you know, the healthcare directive and a DNR or a DNI, and how that's really in certain circumstances. The other thing that you mentioned that I think makes sense to talk about a little bit more is all of us are having these thoughts, but we're particularly thinking about how to take care of frontline medical providers at this time as well. Can you speak a little bit to that? I'm imagining that the advice is also the two key documents are the two key documents.
Right, it is. So, and thank you for helping us through to say that, yes, we do a lot of complex planning, but these two documents are far more simple for us to complete. And it's a huge relief, number one, and it has huge utility. One of the things that we want to be able to do is offer our services to anyone that is serving on the front lines, nurses, physicians, anyone in healthcare. We want to be able to prepare these documents for you at no cost to you. We can hop on a video conference like we're doing now, even FaceTime or Skype. I like to say, you pick your technology choice and we'll meet you there. And we can draft the documents for you relatively quickly, and then turn around, and we do have some procedures where we can sign them also remotely. So, and anyone can share this video or this information with anyone that they know. The more people we reach, the better for us.
We really appreciate the two of you, and I want to make sure that you let those of, you know, your family or friends know who are on the front lines that Disability Planning Partners has made this available, and that you also know that these documents are also important for the rest of us, and that Claudia and Kathleen can help you with that in some of the same manners, right? Also remotely, we could also get that done for people who aren't on the front lines, I guess what we'll call remotely or virtually.
Mm-hmm. Yeah, we're looking at the stopgap really is these two documents. It doesn't take the place of a full plan, but it certainly helps relieve some stress, I would imagine, that something is in place for anybody that is really, really concerned about, you know, they're fighting on the front lines here. The chances of someone contracting the virus are greater than others. And in my book, and I think Kathleen also mimics this, is that they're really the unsung heroes, and everybody says it, but we want to do something that could be helpful long term.
Thank you so much. I think it makes sense to turn now to the connection between why it's your recommendation that these are the two key documents, and transition into what would happen if in the worst case scenario were someone to pass away, because I think that there's a component to these documents that allows the person you name to take care of what would happen if you passed away on your behalf. So that's the bridge that leads Claudia and Kathleen to talk about why these two are the most critical. Can you two explain that a little bit more?
So there's certain aspects of, for example, a power of attorney that allow for your agent to do some planning on your behalf if you've lost capacity. So for example, Claudia mentioned earlier, creating a trust for the benefit of an individual, or updating beneficiary designations on an account. So there are things that an agent can step in and do. But I will say that having an agent and a power of attorney is not a substitute for doing your own full plan.
Full plan.
Yes, yes. And a key component of that, we always start our work with having clients give us a snapshot of what their estate is. And many times people don't even understand what their own estate is. So it's an exercise for us as much as it is for the clients to understand what they have, that life insurance is part of your estate in addition to your bank accounts and any sort of annuities or pension and real estate that you own, and what the implications might be of real estate that's in another state, like a beach or a lake house. So having these conversations and sitting down and really fleshing them out, like I said, can't be replaced by an agent who really only has maybe a picture, a smaller understanding of what your wishes would be on a global scale.
So this is actually, this leads to another point, right? So I'm thinking of that expression, to not let the perfect be the enemy of the good, right? So the idea is, there is a lot of urgency right now. Let's make sure, particularly with first line medical providers, that we're putting the two basic documents together. But the conventional wisdom is conventional because it's correct, that you're not done, that you then need to follow through and do the full plan, so that you really have a plan that's cued in to your goals and what you've thought about, and when you can think on a deeper and more particular level, I think. Kathleen, can we talk a little bit, because when we were talking with Claudia about those two documents, the power of attorney and the advanced healthcare directive, which I'm going to call the capacity documents, and now we're switching over more to what happens in the event of a death. Can we talk about the default there to what happens if you don't have the full estate plan in place? One of the things that I think is very confusing, and it's partially very confusing because it varies significantly from state to state, and how it's depicted in pop culture adds a lot more confusion. But let's talk about what happens without planning, what lawyers call intestacy.
Sure, yes. So the laws of intestacy, so intestacy or being intestate means that you have died without a will. And there's a lot of misconception in general about how property passes. So there's many different ways that property can pass, with a will being one of them. So I'll kind of talk about each one of those in the hierarchy of how property will pass. But ultimately, we have a lot of clients that say to me, okay, so if I don't have a will, then everything just goes to the state, right? And I say, no, but the state is basically writing your will for you. And you can go look at the Connecticut statutes and see what the law says as to where your property will go. And the laws of intestacy, it's challenging to kind of run through all of the scenarios because they're all based on how your family is comprised. So it's based on who's living, whether you're married, whether you have children. But what I will say is that the laws of intestacy are sometimes surprising and not usually surprising in the way that goes.
You want them to be.
Right. So one of the things is that if somebody is married, and they don't have any children, they probably assume everything is just going to go to my spouse if I don't have a will.
That's a very common assumption.
Yes. And one would think that, yeah, that makes a lot of sense. But really what happens is, yes, your spouse will inherit the majority of your estate. But if you have living parents, then some of your property is going to go to your parents. Like I said, the majority goes to your spouse, but most people are leaving property to their spouse and then other people in generations below them. They're not necessarily thinking that they're going to provide for their parents, especially if they're expecting their parents may predecease them, just given the age. Another common misconception with the laws of intestacy is that if you're married, let's say your parents have predeceased you, but you have children, that everything's going to go to your spouse, and that's not true either. Most of your estate will go to your spouse, about $100,000, and then half of what's left over, and then the other half is going to go to your kids. And that can be very problematic. When we were talking earlier about if you don't create a power of attorney, now the court's involved. Well, a court is going to be involved in your financial life if your minor children are inheriting property and money, because that money has to be controlled and managed for a minor child, and it's the court that's overseeing that. So that really underscores the importance of planning and making sure that, number one, you understand what you have, and number two, that you're the one writing your story of where it goes. You know, we all work hard. Everybody works hard for what they have, and no matter what that is, it's substantial because it's yours and you've worked hard and you've earned it, and so you should at the very least be able to say where it goes.
Right.
So, yeah.
And then just, can you talk briefly also about something that's very confusing for people, is what passes via your will and what passes via a named beneficiary. Can you just outline that? Because one of the reasons that you need the full plan is that all of this needs to get lined up and done in accordance with your wishes. Because if you don't think about the things that pass outside of your will with named beneficiaries, it's going to wind up resulting in not your intent. What happens won't reflect what you meant to happen.
Exactly. So our job as lawyers, as Claudia and I often say, is to put legal language to what your intent is. And part of doing that job and doing it correctly is, like I said, we start with the snapshot of what you have, because if I give somebody a will, presumably if they're in my office, they're there for their estate plan, I'm giving them their will. But if that's all I did and I didn't talk to them about how their property is held and their beneficiary designations, then it very well could be that the language that they think is governing all of their property actually might not apply to any of it. So, and that's a really critical piece that we are always explaining to clients, because it's a common misconception. So I alluded earlier to that hierarchy of how your property passes. So first and foremost, regardless of what your will says, any property that's jointly owned is going to go to that joint owner, presuming that you have rights of survivorship. So there's always these, I know it can be annoying for people that lawyers always have these little caveats.
Well, tenants in common.
Yeah, exactly. So I, for example, have a client that I'm working with, and he owns a piece of property with a family member, a non-spouse family member, and didn't necessarily understand why I wanted to see the deed. And I said, well, it's possible that although you own this property jointly, that it's going to go to this other family member as opposed to passing through your will. And this is a sizable piece of your estate. So part of our job is to understand how that property is going to pass. So if something's owned jointly with rights of survivorship, that joint owner is the automatic owner. And that's whether it's a piece of real estate, or it's a bank account that has joint owners on it, or it's a car that's jointly titled, for example. So that's the strongest thing in the hierarchy, is joint ownership. The second thing is a beneficiary designation. So if you have, for example, a bank account that is solely owned with $10,000 in it, and you have your daughter Susie as the named beneficiary, but you also have your sons Adam and Bill, and your will says, I want my all of my money to go to Susie, Adam, and Bill. Well, even though I drafted that will, and my client now walks away thinking that the property is going to go be divided equally, in the hierarchy, that beneficiary designation giving $10,000 in that account to Susie is going to take priority over what the will says. So part of our job as estate planning attorneys is to say, update those beneficiary designations to match what we put in the will, so everything is passing as you expect it to. So first we look, is something jointly titled? Second, does it have a beneficiary designation? And some assets that commonly pass through beneficiary designations are things like retirement accounts, life insurance policies, annuities, things like that. But you can also have payable on death or transfer on death designations on your checking and savings accounts. Or you can even, on the back of your car registration, name a beneficiary of your car. And a lot of these things are really helpful tips that we talk about with our clients, because it gets into, when you've passed away, going a step further than making sure that we've carried out your intent is, how easy is this to get across the goal line? Meaning, how easy is it to get the property to the people you want it to go to? And when there's a joint owner or there's a beneficiary, the property is going to go to that person right away, as opposed to waiting and having the probate court get involved and having longer time periods that are involved before that property can be distributed.
Which is especially relevant now because the courts, in order to keep everyone who works in the courts and of course the public safe, aren't at full operation, right? So what was inconvenient, or I think I've heard probate court intervention called invasive, right? Like that the involvement of the court, if that's not something that's desirable for you, it would be less desirable now because of the time frame, isn't what it normally was. So I think that you've made such good points. And again, we're so grateful to the two of you for being here. One, of course, for making sure that we're educated about capacity documents, the two basic documents. Two, for your generosity in making sure that those documents get executed safely, remotely, and correctly for frontline healthcare providers. And then I also want to make sure that we acknowledge that although we focused on those two capacity documents, none of this is a replacement for a properly done will. And part of a properly done will and estate plan is making sure that like the way I think of it is, it's not worth just the paper it's written on, right? A properly done will and estate plan makes sure that the whole pie of your assets and estate go to the people that you want to get them to, how you want them to get there. And it's just, as deeply as I believe that you should go to a lawyer who does divorce and family law for your divorce and family law matter, I cannot stress the importance of going to estate planning lawyers to do estate planning documents. It's just not the time for a well-intentioned generalist. And that's why we're so grateful to you, to Claudia and Kathleen, for being here. Are there any takeaways that I missed that you want to make sure that we have everyone get, either about estate planning in general or about the current COVID environment?
Just make sure that you start thinking about a plan, and if you have any questions at all during this time as to what can be done with the incapacity documents or otherwise, please call. We're more than happy to answer questions and take a call at any time if we can be of assistance. Thanks so much for having us, Megan.
Thank you so much, both of you, for being here. We really appreciate it. Disability Planning Partners you can get to online. You can, of course, call us or write to us and at Freed Marcroft, or Claudia or Kathleen at Disability Planning Partners, we will get you right over to them on our end, or get them directly. Thanks so much for listening, and we want you and your families to be safe and have all the documents in place that you need to make sure that you and your family are taken care of in the event that you can't make decisions for yourself. So thank you both, and have a wonderful day.